The Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon. Please be seated. We are here at the time set for oral argument in file number 2026-0055, BEK Communications versus the Honorable Daniel S. El-Dweek, Judge of the District Court of the Northwest District. As you may be aware, we've had a couple of disqualifications of our justices on this court. Justice Tufte and Justice Freeze are disqualified today. So sitting today in their place are Surrogate Judge Bruce Romanek to my left, and Judge Jackson Lofgren, District Court Judge Jackson Lofgren to my right. Also sitting today is Justice John Jensen, Justice Douglas Barr, and I am Lisa Fair-McEvers. Arguing this afternoon for the petitioner, I have Robin Forward, and I see that you have saved 8 minutes for rebuttal, and also appearing Haley Finch. And for the state, Amanda Engelstead, who's going to argue the first 10 minutes, and Respondent Brieo, Jesse Wallstead, who's to argue the second 10 minutes. Did I say that name correctly? Is it Brieo? Brieo, okay, thank you. So, Mr. Forward, you may proceed when you're ready.
Good afternoon. May it please the court. My name is Rob Forward. I represent the petitioner, BEK Communications. BEK is asking the court today to exercise its supervisory jurisdiction over the district court in Ward County because that court abused its discretion when it ordered BEK Communications to disclose information that is protected by the Journalism Shield Statute in the state of North Dakota. Before turning to the merits, let me point out the basis for the supervisory jurisdiction that we're asking you to exercise. It's appropriate here because BEK has no other legal alternative. The district court's order that we are complaining about is interlocutory. It's not directly appealable. BEK, importantly, maybe the most important part of this, is not a party to the case, so it would never have standing after a final judgment to appeal. In addition, Your Honor, there is a quirk or a problem with the judge's order in that it indicates that once it completes its in-camera review of the information that BEK is supposed to disclose to it, it is going to then release the information directly to the state. And then from there, the state is then to release it to the defendant. And when a fair reading of that order is that I would not be able to challenge that determination, that in-camera determination, before that release is done.
Would the situation be different, counsel, if the court said it would issue an order for BEK to release it, so then you'd have time to file a supervisory writ if the court actually ordered anything to be released?
If they had done that, more than likely, if the district court had done that, more than likely I would not be seeking this writ.
Because at this point, when you say disclosure, the court's only saying, I get this to look at in camera.
Correct.
And that's, I trust, is not the major concern at this point, is that the court may order it to be released or let it be released to the state without you having the chance to challenge that.
Correct. BEK's position is that an in-camera disclosure is not in keeping with the statute either, Your Honor. But regardless of whether the court agrees with me on that or not, that's not the situation. The real threat here is disclosure, whether that's to the court or later on to the state without a chance to challenge it. The district court has made a number of errors. The first, the district court ordered an in-camera review even though the state did not present any facts or any other basis to trigger an in-camera review. Judicial proceedings have a burden of proof. The state had the burden of proof here under the Grand Forks Herald case. And instead of filing affidavits, deposition transcripts, or calling witnesses at the hearing, the state merely filed a brief. And in that brief, they only presented argument, and none of the analysis and the argument in that brief shed any light as to why the surviving victim's statements might be of interest to the state or, according to it, to the defendant. There was no comparison of, and the victim, it goes by the initials JB. There's no indication in the record or no analysis in the record of JB's prior statements, and she's made prior statements that the state and ostensibly Mr. Brejo have. She made a victim impact statement. She was deposed, and both the defendant and the state have access to that. She was interviewed at least once, probably twice, by the police. So they have prior statements, and if they wanted to, the state could have analyzed those and talked about those in its brief and said, here's why we believe there is enough here to breach the privilege and why we believe she may not have been telling the truth and why we need to see these potentially prior inconsistent statements that she made to BEK during the interviews. And so the bottom line there is that whether it's an in-camera review or a direct release of the information from BEK to the state did not carry its burden. You have to have something, some threshold showing to get an in-camera review. And our position is not only do they not meet whatever standard applies to disclosure to the state, they did not meet the standard to disclose to the court on an in-camera review.
Mr. Ford, isn't that the catch-22, though? How can you make a showing for an in-camera review when you don't know what the material that's to be reviewed contains? Does there have to be some inconsistency in JB's prior statements, the ones made to police versus the deposition? Does there have to be some inconsistency somewhere else to show that the things that are at issue here might have an inconsistency?
And I just used that as an example, Your Honor. They could have called police officers at the hearing and taken testimony from them about why they believe that BEK might have this information. They didn't. They made no threshold showing. And to be honest, if that's all they did, then BEK should not surrender its privilege. Next, Your Honor, the state focused its brief and its oral argument solely on the unaired interview recordings of JB. So JB's a victim. She's interviewed numerous times by BEK reporters. Some of the information is published online and is free to get. We can pull it up right now. And then there's other stuff that's unaired. That's not the only category that they had in their subpoena, but it's the only one they wanted to talk about and defend in their brief before the district court and the oral argument before the district court and, quite frankly, in their reply brief here. And so it would seem that not only did they not carry even a threshold, they abandoned that issue. They gave up on it. Even so, the district court did not quash the subpoena in that regard. It should have, at the very least, quashed the subpoena regarding those other categories. And those other categories that don't involve unaired footage of JB are things like Outlook calendars of the BEK employees, texts between the BEK employees, texts between Ms. JB and the BEK people, communications with any agents of JB, which I assume they meant to mean her attorney. They gave up on all that. They presented absolutely nothing factual and nothing even in their brief, no analysis. So at the very least, the court abused its discretion when it didn't quash the subpoena with regard to those items.
If we agree with you on the failure to, if we agree with you that the district court abused its discretion in not quashing the subpoena, do we still need to get to the question of the in-camera, or is there's different information, or is it, do you see what I'm saying? If we say that the court abused its discretion by not quashing, is there anything else for the court to review in the in-camera proceeding?
Do you mean the categories that I was talking about, or the whole thing?
The whole thing,
The whole thing?
the whole thing. Does answering your issue on failure to quash the subpoena answer the entire question?
Yes. There would be nothing left. And you can get that way through one of two ways, I guess, either through analysis under the Grand Forks standard, Grand Forks Herald standard, Your Honor, or under the Rule 17 concepts. This overlaps. There's overlapping problems with the particular subpoena that I'm talking about. First, really being that it would violate the Grand Forks Herald case and the journalism statute, and the second is that the subpoena doesn't meet criminal rule of procedure 17 and its case law. Next, I want to point out the district court applied the wrong legal standard. The court framed its inquiry this way, and I'll quote directly from the order. The question then becomes whether denying the defendant access to BEK's unaired portions of interviews with JB and the other material subpoenas, I believe what he meant to write there was, I believe he meant to write other subpoenaed material, will result in a substantial prejudice to the defendant. So that's the wrong question. Under the Grand Forks Herald case, the correct question is whether non-disclosure will cause a miscarriage of justice, considering the competing interests of BEK Communications and the state of North Dakota, not the interest of the defendant. The state issued the subpoena, not the defendant. The state directed BEK to produce the information and release it to the state, not to the defendant. The state and the defendant do not share interests. Moreover, the court didn't even mention the Grand Forks Herald case. It didn't analyze the parties' interests under those factors. It should have analyzed the parties' interests under those factors based on the record that was presented to it. Instead, it's not clear whether the court will apply those standards in an in-camera review. And if it does, apparently it's going to be applying it to the wrong interests, the interests of BEK and the interests of the defendant. Next, there is a contradiction within the district court's order, and I think this demonstrates that the order cannot survive any kind of scrutiny. On one hand, the order says that the court cannot make a determination on a miscarriage of justice without an in-camera review. In other words, I need to see it. I need to see this stuff before I can make a determination. And then in the next paragraph, a couple sentences later, the court indicates it concluded that the interview recordings of JB likely have relevant material, but the other information, the other bucket of information that I was talking about, quote, is not likely to have relevant material that, if the state or defendant were deprived of, would lead to a miscarriage of justice. So what does this tell us? This tells us the court did make a determination and didn't have an in-camera review. Not only did it indicate that the non-recorded material was something he wanted to see or review, felt that there was something there, but he also made a determination that the other stuff didn't need any review. And the bigger problem, I think, Your Honors, is that he did not give us any indication about how he came to that determination. It should have applied the factors from Grand Forks Herald, and those are the free flow of information against the age-old judicial canon that all people must be subject to giving evidence so that our judicial system operates correctly. And so what we're talking about is a free flow of information, in other words, the press versus the duty of all citizens to be a part of the judicial system. Confidentiality, a compelling interest is another factor, exhaustion of other means of obtaining the information and whether or not the request or the subpoena is frivolous.
Mr. Forward, does the court have to review those factors before doing the in-camera review or before deciding whether to release the information?
That's a good question. And when you read the statute, the sequence indicates that it makes that determination after the hearing. There's nothing in the statute but an in-camera review. So it's BEK's position that the court should have made its determination based on the record before it after the hearing had concluded. So let's take a look at the factors and how they would apply to this case. The first one that I want to talk about, and I believe is the main question, is why does the state want this information? How is this a compelling interest to the state? And when you read their briefs and listen to their oral argument, you'll determine that it's not to obtain information to prove up an element of the crime or otherwise make it, shouldn't say easier, but make their job better to find a guilty verdict against Mr. Brejo. But they've indicated that they have two reasons for this. The first one is that they have a right to discovery. I don't think the state will dispute, and it appears that in their brief in response to the petition here, that they've conceded that this is discovery mechanism. The second reason is that they've advocated that they have to do this in order to fulfill their discovery obligations under Rule 16 and under Brady. I'll take the last one first. Our case law is pretty clear that under Rule 16 and under Brady, the state has no duty to seek out evidence and do the defendant's job for them. Sure, they have a duty to disclose evidence that they have within their own possession or within their orbit of control. So I think of Department of Transportation on DUI cases, or maybe the Bureau of Criminal Investigation, police force, etc. The state concedes, and nobody disputes, that BEK is not within the orbit of control of the state of North Dakota. So it's not a state actor here. So we end up with the conclusion that the state does not possess the evidence that BEK has, obviously, otherwise there'd be no need for a subpoena. So the Rule 16 and the Brady implications for Mr. Brejo are never triggered at this point. Sure, once that information is given over to the state, then yes, all those things are triggered. But as of right now, it's not. And so that reason for the compelling interest or critical need on the part of the state to obtain this information, that just doesn't hold. That's not a valid reason. Secondly, and I'll get into this a little bit later, further when we start talking about Rule 17, but you can't use a Rule 17 subpoena for discovery. It's in the commentary, it's in federal cases. We don't have many cases interpreting and discussing Rule 17 in North Dakota. However, there is a raft of them at the federal level. From the Nixon case that set the standard and the different tests for a Rule 17 subpoena on down to some great cases in the Eighth Circuit. There is a Hardy case that we cite in our brief. There's a Hang case that we cite in our brief. Let's talk about exhaustion of the ability, or the exhaustion of other means to obtain this information. The Grand Forks Herald factor talks about this is something that a court can consider, whether or not a party exhausted other means. The implication, obviously, is that they would rather the state look for other ways to obtain this information first before imposing upon the privilege. The state has made...
Such as what, like For example, asking JB to consent to the disclosure since she's the one who wanted this to be confidential?
Exactly, Your Honor. Yes. And they only addressed the unaired footage here, meaning the state. They didn't address those other factors. They didn't talk about how they had tried to obtain any of her texts. You know, she was texting back and forth between BEK and they want those. They should first approach her about that. If they can use subpoenas the way they think they can, go ahead and subpoena those. In addition to her attorney, if they want the communications between BEK and her attorney, go talk to her attorney about that. Issue the subpoena if they think they have the subpoena power for those. So that's the exhaustion that needs to take place, Your Honor. Confidentiality. The state has argued in their brief that BEK has not met its obligation of showing good confidentiality. I guess those are my words. But I would advocate that it's established. There's almost a presumption that there's going to be a chilling effect on the freedom of the press if there's confidential information that's being sought and has to be disclosed. Our Supreme Court in Grand Forks Herald puts out this general statement. There also appears to be little doubt that a forced revelation of a confidential source by a newsgatherer could have a chilling effect on the ability of newsgatherers to obtain confidential information in the future. A couple more words about Herald. I just want to distinguish that case for you because I think it's important to note that in that case there was no confidential information. And so the interest, when you're balancing these things, you're balancing the newsgatherer's privilege, right to the privilege against the state's right to have the information or civil litigants' right to have that information so the legal system can work properly. The newsgatherer's side of the scale becomes a lot more light, as I understand the reading of the Herald case. That's not what we have here. Incidentally, there was no in-camera review in Herald. And there was no in-camera review of the Moore case, which, as far as I can tell, was only a summary affirmance by this court of a post-conviction proceeding. In addition, there was a compelling interest that the parties could talk about there. The compelling interest is that the only evidence of the point of impact between these two vehicles, I believe one was a motorcycle, another was a car, were the photos that the Grand Forks Herald had in its possession. That was the only evidence that they had. Not only that, the party that wanted those photos knew that they existed, and they knew what they wanted. They were able to articulate what they wanted and how it was going to affect their case. We don't have that here. We have speculation that the...
You can continue if you want, but you will be in your rebuttal time, so you can continue.
Okay, I'll finish my sentence if I can remember what I was saying. The speculation the state and Mr. Brejo are making is that Jenny Babcock, JB, has made inconsistent statements in the recordings that BEK has. That's not enough.
Thank you, Mr. Forward. Ms. Engelstad, when you're ready.
Chief Justice, Your Honors, Counsel, may it please the court. My name is Amanda Engelstad. I am normally here on behalf of Stark County. I'm the state's attorney, but I am here today as a special assistant War County state's attorney. I took this case on a conflict. So, and I just want to apologize in advance. I've been kind of fighting influenza, so if I have a coughing attack, I apologize. So BEK TV has asked for the supervisory writ. The statement of the issues presented for review were two, as Mr. Forber talked about. The first one was whether the district court abused its discretion when it failed to apply Grand Forks Herald and ordered the in-camera review of all, BEK interview recordings of JB. And what the state, is arguing is essentially that is BEK putting the cart before the horse. The in-camera review is a gatekeeping, power that the court has so that it can review instances of privilege, right? Like if there's someone makes a request and there's a attorney-client privilege, medical privilege, child abuse records a lot of times have those privileges. And the court, before it can make any, educated opinion on whether those privileges apply, has the opportunity to order this in-camera review. And in fact, this court took up a case very recently, which is Haskell v. Grand Forks Public School District. It's 2026 Indy 40, which was a case, where an individual, a board had an executive session that involved an individual, and that individual wanted that executive session, which is protected under the open records and open meetings for attorney-client privilege. And that court essentially said, no, we're not going to conduct this in-camera review. We have enough from the essentially assertions of the government attorney. And what the court found there was that was actually an abuse of, this court found that was actually an abuse of discretion by the district court. They had said that the district court should have taken that information, reviewed it in camera, and then decided what privileges applied, whether that attorney-client privilege applied within that executive session.
So, Ms. Engelstad, is it your position that the state doesn't have to make any showing at all? Just
No.
say there's information, we don't know what's in it, and so you should review it in camera.
Well, like in Haskell, the court stated that the Haskell would have known, or there was an inference that the executive session essentially was in relation to her claims. They went into executive session because of her claims. The same can be stated.
Isn't the open records, open meetings law completely different than what we're discussing here? Here we have a statute,
Correct.
and we have a case defining how to apply that statute.
Well, I think we don't get to the statute, though, until the in-camera review is conducted by the court. Like I said, I think the court has that gatekeeping power before they even get to decide if there's a manifest injustice. I don't know how a court can decide if there's a manifest injustice that's going to occur if they don't have an opportunity to review that information. And like in Haskell, they said, we know that this information is about her because the executive session was about her. What BEK has aired is about the Brejo case. And not only that, the record that was supplied to the court, I believe it's page 58, it's the declaration in support of motion to quash subpoena by Derek Balawa, paragraphs 5, 6, 7, and 8, and this was in front of the district court, said, I'll read it quickly. Dunseith declassified as a local story focusing on the criminal investigation of Daniel Brejo and includes episodes featuring interviews of Miss Jennifer Babcock by BEK News reporter Lori Heinz. Miss Babcock is a victim of a shooting allegedly done by Daniel Brejo, as alleged in this case. It talks about how it first contacted Babcock, and there was a initial call. And then it says, thereafter, BEK and Miss Babcock corresponded about the criminal investigation and arranged for Miss Babcock to be interviewed for news gathering purposes. BEK conducted a series of interviews with Miss Babcock from December 2024 through September 2025 in response to the criminal investigation of Daniel Brejo and the underlying criminal case. The court had that in front of it. It knows that this series was focused on the criminal case, the criminal investigation of Daniel Brejo, and Ms. Babcock, I think it's been said over and over and over, is the state's only surviving victim and the state's only eyewitness. So what she tells them is going to be relevant, and it's likely going to be evidentiary for evidentiary purposes. And then I'll get to Rule 17 here, but just quickly, you know, the reason for the unaired and unedited footage is the state has to analyze how that footage was edited, how the question was posed. Was certain information edited out that might make that question or that statement or the answer by the victim maybe in a different light? And the reason the state went about it this way is, again, Mr. Wallstead could have easily subpoenaed this information, and maybe, you know, depending on what this court does, he will. However, the discovery rules, and I know that Rule 17 isn't a discovery tool, and I'll get to that, the discovery rules are not the same for the state and for the defendant. So had the defendant subpoenaed the information, had this court, the district court and this court decided that he would get that information, he doesn't have to supply that to the state. So the state's then at a disadvantage. And let's say hypothetically we're in trial, he decides that he's going to give, you know, this information to the state and to the court, and he wants to publish it. The state has no time at that point to look at what he has been, or what he plans on publishing to the jury. And so then what does the court do? Does it take a week recess so the state has the opportunity to review that, or is the state just put at a disadvantage? And I guess that rolls me into my Rule 17 argument. As this court knows, the statute says that there can't be, the disclosure of information cannot happen without a hearing. So that completely takes like a search warrant or anything off the table for the state. We went about it in the correct manner. There's no other way for the state to gain this information other than using the Rule 17 subpoena power.
So, Ms. Engelstad, is your position that the state could not have sought a search warrant for this information?
Correct. I believe that it could not, and I don't remember exactly the name of the case, and I apologize for that, Your Honor, but within the recent past, I know that there was a search warrant that BCI conducted on a journalist, and it really caused quite a problem. And that I believe the statute was brought into play that said you could not gather that information without a hearing beforehand. So we did. The state subpoenaed the information. And it's correct. It's not a discovery tool. However, Bowman Dairy Company v. U.S. 341 U.S. 214, which is a case that that BEK TV cites in its brief. It also talks about that, yes, it's not a discovery tool, but it says the plain words of the rule are not to be ignored. They must be given their ordinary meaning to carry out the purpose of establishing a more liberal policy for the production, inspection, and use of materials at the trial. Again, from their own affidavit and from what the state has seen that has been publicly put out, this is very, very relevant information to the state. And when I say the discovery rules and Rule 17 in this case are very intertwined, I know to some degree, right, what is in those public aired footage, and I know that in the event that what I believe to be in there will perhaps be given to the state is likely going to be discoverable under Rule 16, and that's why the state made the argument that it did. I think I've got very few seconds left. I think the state has met its burden for the Rule 17 subpoena, and again, I think that cart before the horse is the real argument here as when it comes to the district court's order.
Thank you, Ms. Engelstad. When you're ready, Mr. Wallstead.
Good afternoon, Chief Justice, Justices of the Supreme Court. Judge Romanek, Judge Lofgren, esteemed counsel, may it please the court. We are now living in a true crime podcast world. I think this is important. This petition asks this court to curtail ostensibly the district court's authority to order an in-camera review in the context of a subpoena dispute where one non-party holds sensitive but disputed records. The court should not accept this invitation to deprive the district court of this protective, discreet judicial tool for unraveling these sorts of disputes. As Ms. Engelstad articulated, they can arise in a myriad of contexts, but before digging into the merits, I would caution the court to carefully consider the ripeness of this petition, because while there is not much guidance in the law, the Grand Forks Herald case is nearly 40 years old. I would anticipate this sort of issue arising with increased frequency as the nature of investigative journalism changes. It's evolving, same as our own profession, increasingly to include podcasts and an ever-expanding marketplace of investigative journalist productions. Now, with that in mind, I think you can't miss the point. I think this is the catch-22. The district court has not issued a final order on BEK's motion to quash. Now, I agree with Mr. Forward that this matter is interlocutory, that BEK is a non-party, that it has no direct right to appeal, that once disclosure, and by disclosure I mean production to the parties, is ordered, it cannot reasonably be undone. But the court's January 26th order, the Exhibit 12, does not do that. It merely...
But Mr. Ford, would you agree with Mr. Wallstead, would you agree with the arguments of Mr. Ford that the court said, it didn't say it's going to issue an order for BEK to disclose anything. It said, after I review it, I may give it to the state. And what remedy do they have then?
I do not agree. I do not disagree with you, Judge. I don't disagree with Mr. Forward on that. The last paragraph of the order is not clearly written. It would be my presumption that a final order on BEK's motion would issue, and that final order would articulate the Herald factors and things with greater specificity. And that, as the court indicated, then any party may take a position on that order. So I do agree. But to your question, Justice Barr, what remedy? I don't think then that the remedy, as the petitioner asserts, the petitioner is asking for the court's January 26th order to be vacated and the subpoena to be quashed. I don't think that would be the appropriate remedy, to the extent that any of the findings of fact or conclusions of law that the district court articulated in that January 26th order may be insufficient or misleading procedurally. Then I think the remedy would be to return, to remand this back to the district court with some instruction on how to make findings of fact and conclusions of law that would clarify the procedure here. And I think that would be valuable in the interest of improving our law, because as I said, it's been 40 years since the real substance of the Herald case. I think things have changed. But I would urge the court not to decide this case in such a way that it takes that valuable, discrete tool away from the district courts.
To that end, Mr. Wallstead, in your position, in what order should the district court have analyzed this? It seems like there's no need to get to the Grand Forks Herald case if the court had done the analysis under the motion to quash under the rule. I mean, it should be a step-by-step process that if the court decides under 17 that it's going to quash, there's no need to look at it under Grand Forks Herald. So it seems like it put the horse ahead of, or the cart ahead of the horse by going right to the in-camera review.
And I would agree, Your Honor, and I would agree with Mr. Forward when he answered your question earlier, that if the district court had quashed the warrant under Rule 17, then that's it, game over. There's no need for additional investigation or additional analysis. But I think that would create problems. I think that those problems would present because, well, first, let me talk about Rule 17 quickly. So the petitioners raised essentially three arguments. First, that Rule 17 does not allow discovery. Second, that the subpoena was overly broad. And third, that Rule 17H prohibits or bars subpoenaing witness statements. First, as to the discovery question, I think it's important to note that the explanatory note that the petitioner asserts, and I'll quote, Rule 17 is not a discovery device. It omits the first clause of that sentence within the discovery within the explanatory note, which states, Rule 17 is allowed to obtain witness and documents to be used as evidence. Now, the Hang case, the Eighth Circuit case that the petitioner has briefed and argued, I do think it's reliable. I don't think it stands for the proposition that the petitioner asserts. In that Hang case, the Eighth Circuit looked at the federal Rule 17, much like our state Rule 17. It is not specific about whether or not subpoenas ducus tecum to a third party are permitted. There, the Eighth Circuit, in that Hang case, said that its interpretation of Rule 17 and their analysis of other districts and so forth, support the finding that Rule 17 does permit subpoenas ducus tecum to third parties. They ground their analysis in the principles of fundamental fairness. I think that this petition is really about fundamental fairness. So first, does Rule 17 permit a subpoena ducus tecum? I believe it does. I think it's inherent in there. I think Rule 17 could be clarified state and federally, but I think that other courts have in the interest of fairness, determine that subpoenas ducus tecum are permitted here, and I think that also squares with the State v. Lind case from this court in 1982, which is also briefed by the state. Their second argument that under 17H that witness statements are not are barred under Rule 17, I think is a little bit of a misconstruction. Under Rule 16F4, it defines statement for these purposes in relevant part as a recording of an oral statement, and I quote, made to an agent of the prosecution. I think we all agree here, it's not disputed that the statements, the recordings at issue here were not made to an agent of the prosecution. So how do I read those two things together taken as a criminal defense lawyer? In criminal cases, when I hear discovery, I hear Rule 16. In civil cases, when I hear discovery, I hear several different things. So if I look at the explanatory note from Rule 16, Rule 17, this is not a discovery device. What that means to me is I'm not permitted to use Rule 17 to subpoena the Bismarck Police Department to provide me a statement that I should be getting under Rule 16 from the prosecutor. I do not read that rule to suggest that I and the state have no authority to subpoena a third party for a recording that was given to an agent of the prosecution. So I would square those two things that way, Your Honor, as far as the Rule 17 question. The argument that the subpoena was overbroad, I think, is well, it's clear in the affidavit submitted by the petitioner that they understood exactly what was being requested here. They identified the 5 interviews, the dates on which they recorded, and exactly how many minutes those interviews were. I think the specificity there is met. But turning very quickly to the question of burden with the little time I've got left. The petitioner argues that the state failed to satisfy its burden. The district court hasn't resolved the motion yet. The state does hold the burden, and that's pretty clear under the Herald case. But I think the real question in this context is what burden precedes an in-camera review. And I think the answer to that has to be either no burden or a prima facie burden. Because I don't see how even taken outside the context of this case, a party moving, to quash a subpoena or to compel disclosure or whatever, if they hold a burden and the only information that can resolve that question, that legal question for the parties and the court is withheld in the possession of a third party, the court has got to conduct an in-camera review in order to get to a credible legal conclusion. If it doesn't, if the burden comes before, the full burden comes before the in-camera review, then I don't know how in those contexts parties can be expected to satisfy their burden. And it also incentivizes then third parties who are holding information to hide the ball, because if that burden can't be satisfied, then we don't even get to an in-camera review. There's not a situation where anybody's even going to look at the information. I think that would be a dangerous precedent. So I would urge the court, to the extent the burden needs to be resolved there, that either the district court has not gotten to the question of burden yet because it has not completed its in-camera review, or that there is a prima facie burden, that being demonstrated in the
Your
record.
statement, Mr.
Thank you,
Volstead.
Your Honor.
I just want to clarify a little bit about Rule 17, the criminal rules of criminal procedure, excuse me. It does directly authorize a subpoena ducis tecum. That's Rule 17, Part C. A subpoena may order the witness to produce any books, papers, documents, data, or other objects the subpoena designates. The court may direct the witness to produce the designated items in court before trial or before they are offered into evidence. When the items arrive, the court may permit the parties and their attorneys to inspect all or part of them. So it does appear that that is limited to proceedings and not just an open-ended discovery device like what you have with a Rule 45 subpoena in a civil matter. In fact, the commentary at the end indicates that subpoenas are to be used for preliminary hearing, in aid of grand jury investigation, for deposition, or for a determination of an issue of fact raised by a pretrial motion. In other words, let's get people into court to testify and find out what they have to say. That's what that device is for. It's not a discovery device. The state indicated that the information that BEK holds is very, very relevant information to the state. The question is how and why. They're focused on those pre-existing statements that she made in the unaired photo and the unaired recordings of BEK. We need to see how the footage was edited. I've never heard that before. That's the first time we've heard that reason out of the state. So I think the implication is perhaps what has been published by BEK is either misleading or could possibly shed JB in a bad light or a good light. I don't know. But that was baffling. That's the first time I've heard that. That is not a good enough reason to violate the privilege afforded by the statute to BEK. I think the questions in the discussion about in-camera, really, you don't have to get to whether or not an in-camera review is available here, because the state did not present enough information and carry its burden to even get an in-camera review, let alone pass muster under the Grand Forks Herald case. So I don't believe the court has to address that question today. If there's no other questions, Your Honor, I ask the court to vacate the order and quash the subpoena.
Hearing none, thank you, Mr. Forward, for your argument this afternoon, and Ms. Engelstad and Mr. Walsted for yours as well. This case will be taken under advisement, as all cases are, and court is adjourned until Tuesday, March 24th, 2026 at 9:30 a.m.
All right.